This is Joe Bowser from Roth Jackson here with another edition of Readymode's TCPA compliance series. Today we're going to be talking about the importance for agencies and BPOs, or business processing outsourcing organizations, of TCPA and related compliance. So, agencies and BPOs, you're essentially making calls on behalf of your clients or receiving calls. So the question often becomes, why do I care when I'm using someone else's name on my calls? You care for a host of reasons, not least of which this is what you do. A careless or reckless Uber driver isn't going to be an Uber driver for very long if they're careless or reckless. So if only for reputation and business promotion reasons, you need to care about TCPA. But the TCPA makes you want to care because there's two kinds of liability under the TCPA. One is called direct and the other is called vicarious. And if you make calls that violate the TCPA, you can get yourself and your client into trouble under the TCPA. So under the FCC's guidance, which probably prevails under McLaughlin and Loper-Bright and Supreme Court cases that allow courts to now decide what the TCPA really means, but in any event, you can be liable under the TCPA for making unlawful telephone calls that violate the TCPA. It's that simple. You are the one behind the telephone, you and your agents. So you are capable of being sued directly for the calls or texts that you make in states where texts violate the TCPA. So because you are exposed to direct liability by virtue of being the company making the calls, you absolutely need to care. Then there's the doctrine of vicarious liability. So your customers care too. Because if you're violating the TCPA, the plaintiff's lawyers are not going to be satisfied by just going after the caller itself. If you're making calls on behalf of Acme Corp, they're going to sue Acme Corp too. Because if they can allege plausibly that Acme Corp gave you actual authority, or you had apparent authority, or they even ratified your TCPA violations, they can allege a violation of the TCPA against them as well, against your customer. So because of the two doctrines of direct and vicarious liability, you need to care directly, and you need to care indirectly because it would get your customer sued, and you often will be signing a contract that promises to indemnify, to defend and indemnify your client for any alleged TCPA violations. But that cuts in both directions. If you are calling customers or potential customers from a list of targets or contacts that your customer gives you, you obviously want to make sure that you're doing your due diligence and vetting your client's practices for sourcing those contacts. You want to ask for representative examples of what that consent form looks like. Make sure that calls can be made in their name and on their behalf, because you are now making calls on behalf of Acme Corp. And so you want to make sure that you're doing your due diligence and asking your clients, where are they getting the numbers that they're asking you to call on their behalf? So under direct and vicarious liability, you're now in a partnership with not a legal partnership, but you're in a community where you need to make sure that everybody's rowing in the same direction, and that the company that can bear the risk the best is actually the company that's bearing that risk in terms of TCPA compliance. So direct and vicarious liability ensure that both you and your customer care about how you do life, and importantly, how you train your employees. So there are serious consequences to TCPA violations, which are oft cited. If you make 227B violations, Congress gave a private right of action, which is a right to sue to anybody who gets 227B violations. Those are pre-recorded artificial voice or auto-dialed calls, and we've got other videos on those topics, so you can dig more into those. But if you make a 227B violation, each call is worth $500 to start, and the court can treble that to up to $1,500 for willful violations. If you make a DNC violation, if you make a sales call to someone whose number is on the DNC and you don't have a lawful basis to do so, such as prior express invitation or permission, colloquially called consent, or an established business relationship with that person, they can sue for up to $500 per call. And if the violations are willful, Congress has given courts the power to triple those values. So very serious consequences of violating the TCPA. So pencils should be sharpened, and you should absolutely be paying attention to your TCPA compliance obligations. Some of the most eye-popping judgments and settlements in the country have come from TCPA cases, which is why it's the darling of the plaintiff's bar and has been for 20 years now. 9-figure judgments, numerous 8-figure class action settlements, $75 million, $65 million, Capital One, Papa John's, the list goes on. Thousands and thousands of TCPA cases are filed every year, and it is not slowing down. And these days, 75 to 80% of them are filed as putative class actions. So they are trying to probe the bona fides of essentially every single call you make for the last 4 years. So they are distracting even if they are meritless. It makes great sense to have a compliance-focused regime from day one. And even if you haven't been there, it's the old Chinese tree proverb, the best time to plant a tree was 20 years ago, the second best time is today. So get with your compliance team, get with competent TCPA counsel, and make sure that everybody's in alignment on what needs to be done. And this raises the importance of training. You're only as good as the people who are making the calls for your company and for your clients. So they need to understand the internal do not call list rules. They need to know that if someone says, I don't want to hear from you again, that they disposition that call immediately after the call and make sure that that gets on your list. If you have multiple platforms or multiple ways that you're communicating with consumers, you need to sync those lists timely, ideally daily. The law gives you a bit of a grace period, but you don't want to continue to call these folks any longer than you have to. So you want to make sure that you're training your people on internal D&C practices. Many states have name disclosure requirements. So here in Virginia, for example, you're supposed to use your first and last name when you're making sales calls. Outside of the TCPA, the so-called TSR, the telemarketing sales rule, administered by the Federal Trade Commission, has rules around how you craft your scripts and how your employees talk to prospects. You can't make calls that are false or deceptive or misleading. And so you want to make sure that you're listening to your team and how they're interfacing with prospects, and making sure that they're being fair and accurate in the way they characterize the goods or services that you're trying to sell on behalf of your clients. You want to make sure that you're getting feedback from your clients, that your scripts are staying aligned with the goods and services that you are actually trying to market on their behalf. So training is key. You want to make sure that you're staying abreast of how your team is doing. Regular monitoring. If you record, a dozen or so states are so-called two-party consent states. So if you do record, you want to make sure that you are letting the called party know that the call is being recorded before you do so. But then that is an excellent resource for training and management. That's also a great feedback loop to communicate with your clients to make sure that your scripting and your performance is in line with their goods and services and their expectations under the agreement. So high level, serious consequences for not violating the TCPA. There are all the incentives in the world, both because you can get sued, your clients can get sued, and it's terribly distracting to business even when you've done everything right. And there are certainly high volumes of TCPA cases that are filed solely to extract settlements from otherwise compliant businesses, but you want to document those things. And the other thing you can do is make sure that you're working with technology providers that make your compliance journey easier. So you want to have platforms with D&C integrations like Readymode that have multiple opportunities to integrate with technology platforms to make sure that your calls are being answered from the phone numbers you're using. D&C compliance is integrated. They have disposition abilities to make sure that your team is readily dispositioning internal do not call requests and the like, and getting things escalated to management when that needs to happen. So TCPA compliance is key, especially when you are the one picking up the telephone. Like I said, Uber drivers that are careless or reckless aren't going to be around very long, and so too with agencies and BPOs that are not paying close attention to their TCPA compliance. That needs to be bread and butter for your business, and Readymode is a tool to help you do that. So again, Joe Bowser from Roth Jackson here in Virginia with another edition of Readymode's TCPA compliance video series. Have a great day.